Good morning. Welcome to Deb's True Crime Notebook. We'll reread the documents for you so you don't have to. Well, another day, another defense document. We'll see what they have to say in this one. It's a new motion in limine. Let's get into it. State of Indiana versus Richard M. Allen, motion in limine. The defendant Richard M. Allen by counsel Bradley A. Rosie moves the court as follows. 1. Defendant Allen is charged with 2 separate counts of felony murder pursuant to IC 35-42-1-1-2. Number 2. Defendant Allen has reason to believe that the state of Indiana may seek to admit at the trial of this cause testimony from various prison guards, inmates, law enforcement officers, and possibly the testimony of other IDOC staff members as to defendant Allen's mental state during his detention at Westville Correctional Facility and Wabash Valley Correctional Facility. The defense believes the state's offering of said testimony will be given by their desire to use said guards, inmates, administrators, and law enforcement officers to establish the veracity of alleged incriminating statements by a defendant Allen. 3. The specific individuals have been identified on both the state's witness list and defense witness list, which were exchanged between the parties prior to the filing of this motion. The defense desires not to list each and every witness in this motion so as to maintain some confidentiality, taking into consideration the public interest in this case and the forthcoming trial. The defense will offer up the names of the said witnesses at a hearing on this motion or upon request by the court, whichever applies. 4. Defendant Allen believes that such testimony would violate Rule 701 of the Indiana Rules of Evidence. The witness do not have sufficient life experiences that would permit making a judgment as to the mental state of defendant Allen on the dates and times in question, or on any date and time before or after Richard Allen's arrest. 5. Said testimony would violate Rule 702 of the Indiana Rules of Evidence, as the prison guards, inmates, law enforcement officials, and some of the administrators have no expertise in the field of mental health and therefore are not qualified to draw such conclusions. 6. Said testimony violates Rule 704 of the Indiana Rules of Evidence, as the testimony amounts to the witness drawing an opinion on an ultimate issue. For example, whether or not the witness believes the defendant Allen is guilty of the charged allegations. 7. Finally, said testimony would also violate Rule 403 of the Indiana Rules of Evidence, as it tends to be confusing and misleading to the jury due to the lack of expertise in the field of mental health with regard to any of the referenced witnesses. And Number 8, such evidence is not necessary for a full and fair determination of the facts in this cause. Signed, Bradley A. Rosie, 23365-09. And there it is, the first document from the defense of the morning. We'll see how many we have for the rest of the day. We'll see you next time on Deb's True Crime Notebook. Don't forget to like, subscribe, ring the bell for all notifications, leave us a comment, share this with your friends and in groups.